Viewers, welcome to the weekly episode of The Law Lab. This is the only law show that gives you all your rights, explains to you what you need to do to protect yourselves and understand a bit about the law. My name's Tony Carbone. I'm the managing partner of Carbone Lawyers. With me today, I've got Joseph Carbone, a senior associate at Carbone Lawyers in work cover and litigation, and a senior associate, Nadine Hanna, in work cover and litigation. Good evening.
Hello, viewers. Thank you, Tony.
Now, viewers, we've got a must-see here episode on work cover. Now, the work cover system is incredibly complicated, isn't it, guys? Absolutely. There's so many tricks, trips. There's so many ways of getting stung.
There sure is.
Yep.
Yes.
Now, we've got a couple of cases we want to do just to highlight the vagaries of the system. And the first one I want to talk about is the case of Mackenzie and Healthscope Operations. It's a 2020 Victorian Court of Appeal decision. Joseph, do you want to give us the facts of this case?
Yes, Tony. So Mr. Keith Mackenzie sustained a psychiatric injury in about June of 2014. The claim was accepted. Then about 100 weeks later, so in about March of 2016, the work cover agent terminated his payments, his entitlement. He then appealed the decision to the Accident Compensation and Conciliation Service.
Nadine, the thing about the system is that before you can go to court, you've got to go to this conciliation service. In a nutshell, what is it?
So it's a dispute resolution service, Tony. So when any notices are issued by the work cover insurer, the worker has strictly 60 days to be able to make sure that they dispute this notice.
They seek a review. Yep. Now, the thing is, lawyers aren't allowed to be present without getting permission.
That's right.
From the conciliator and also the insurer. Now, the only time lawyers appear is if there's a self-insurer, which is these big companies the in-house.
The whole idea of conciliation is it's meant to be an informal, efficient type of way of settling disputes that can be settled before having to issue proceedings in court. And that's the main aim of the service.
And the reality is a lot of matters don't resolve at conciliation.
Well, that's right. I think a lot of our clients will come to us and our recommendation would be, look, we don't necessarily recommend that you accept limited periods or offers at conciliation because it could shorten the lifespan of your claim or stop any potential entitlements or deterioration, if heaven forbid, that might cause in your injury.
And we'll be dealing with that in due course because it's a very important consideration what you settle for at conciliation.
Right.
Now, one of the things you raised, Joe, this is a psychiatric case, psychiatric injuries, a lot of bullying, harassment, intimidation at work. I personally think that we've got almost a pandemic in psych cases these days.
Well, we've definitely seen in the last maybe 5 to 10 years a massive flurry of psych cases coming in through the doors. They're just as common as physical injuries now, if not probably even a greater portfolio of psychiatric conditions exist than the physical injuries.
It's a real problem. It really is. Yep. I mean, I saw when we had the problems with RSI and all these different, generational things, but psychiatric problems are becoming more and more commonplace.
I also think that people probably have less tolerance to what they put up with in the workplace, to be frank, as well. Things that might have gone through to the keeper back in the day probably won't be accepted nowadays, and that's probably not a bad result in many aspects.
And Nadine, one of the key elements to these claims when you're lodging complaints, because there seems to be a massive overlap between the work cover benefits and rights and also Fair Work Act, it's absolutely critical that the injured party makes sure that the complaint reaches management, correct?
Absolutely. Complaints with management, whether it would be oral or written, we always say to our clients, preferably written, so there is a paper trail so we can see what has happened in the course of their employment.
Because, see, the courts have said, there's a High Court decision of COLA, and just in general, the courts have said that if the management isn't privy or aware of your complaints, well, then they can't do anything about it.
Well, that's exactly right. How could the employer do anything if they weren't aware? How could they protect the worker if they weren't aware?
And the sad thing about these sorts of claims is that a lot of these people were too scared to put in complaints because they're worried about losing their job in an environment when jobs are very scarce anyway. This COVID thing's caused all sorts of problems.
Exactly right.
Yes, it sure has.
What was the decision in this case?
Look, in the end, what occurred was that the worker, Mr. Mackenzie, decided to take an extra approximately 6 months' worth of payments and not thereafter, which got him to the 130-week period of payments.
Just on that, Nadine, what's the 130-week test? That's a real problem, isn't it?
So weekly payments will be terminated for a worker if they have a work capacity or they show a capacity of some sort.
And it doesn't have to be in the same job.
Not
it
at
could
all.
be doing it in any other job.
I say to my clients, you could be a feather picker in a feather factory, counting feathers. If you can do that job, they will cut your payments.
And sadly, Joseph, it's an in-theory test, isn't it?
It is, unfortunately. I mean, in reality, a lot of the times the jobs that are proposed by the insurers and the recovery services are realistically not going to be achievable by a worker, but they're raised and, if you've got the theoretical capacity for employment, a lot of the time that'll be accepted as precluding you from getting further
benefits moving
entitlements.
forward. Now, just on this case, and I want to be quick, this fellow tried to reinstate his benefits after he'd settled it at conciliation, and he appealed it because they said, no, you've already settled. And under work cover, you can only settle under Division 3A, where there's a contract between you and the insurer to settle your benefits. Now, that didn't happen in this case, and having said that, he still failed.
Yeah, that's right.
It's a bit of a harsh decision, wasn't
Harsh decision, because I understand that there was a deterioration in his condition.
Yes. Usually what happens, Joseph, is that if you've settled a matter like this and then your condition deteriorates, you usually get a certificate off the doctor, write to the insurer again saying, look, our client's condition deteriorated, please reassess his benefits. Is that how it works?
Correct. Look, I guess the moral to the story is that before you head into any decision or any outcome through conciliation, you should be seeking legal advice, and you should also very carefully consider what the consequences are going to be of accepting an offer at conciliation.
And just on that point, Nadine, some self-gratification. These people have been receiving no benefits for about 2 or 3 months. They get a small offer of a couple of months and they want to take it because they figure, geez, my situation's so bad, I need to take the money. But then they've got to look beyond that.
It's all about the bigger picture in
Yeah.
these kind of cases. There's a lot there.
And we know for a fact now too that there's the bigger picture also is common law damages.
Exactly right.
You know, if you follow through with the complaints procedures and they fail to follow policy and their own code of conduct, it's reasonably easy to prove negligence, and then it really comes back to how bad your injuries are.
So it all comes down to make sure that you're obtaining that correct legal advice or accurate legal advice before any potential settlement might occur, because you can always jeopardise, or there's a risk of jeopardising a larger case at stake.
Of course. And Joe, on that, you've got the free call number, haven't we?
Yes, we do.
What is it?
The number is 1800 369 888.
Now, let's get on to the next case, the Age Company versus YZ. YZ's a pseudonym. Court of Appeal decision, December 2019. What are the facts of this one, Joe?
Yes, the trial judge in the county court initially gave YZ, or the pseudonym YZ, who was a reporter for The Age, $180,000 in damages for psychiatric injuries she sustained whilst working at The Age, including PTSD, which is a very severe psychiatric condition. YZ was a reporter, and what she reported on throughout this period were the gangland killings.
So she was exposed to some pretty graphic and gruelling sets of facts and circumstances.
Yes.
Yep. Now, Nadine, in this case, this particular reporter was exposed to a lot of traumatic events and horrific scenes of murders and deaths and whatever. So the thing is, the Age appealed it, saying that there was no breach and that the award was too high. What did the Court of Appeal find?
They disagreed. They actually said that the breach of duty, or the duty of care, did exist considerably in certain parts of her course of employment, and particularly when the employer was aware of her complaints about the trauma that she was experiencing many years before she ceased employment.
And I think, Dean, as well, I think in 2011 the training editor sent an email to the actual editor saying that she's suffering from nightmares and depression due to what she's seen as a reporter and whatnot. So
there was a simple solution to all of this. Take her out of that environment of the gangland killings and get her to report on other things.
Rotate her duties.
Yeah. And I think that is the best way an employer can protect themselves.
Further to that, in this case, she actually said when the age wanted her to go back into court reporting, which is not exactly the same as reporting, but reporting on the news in the courts, she said to her manager that she was not coping, and that she expressly stated that she didn't want to go back into that role.
And the thing is, employers can't be pig-headed about this, because what you and I have found over the years is that when someone has a physical injury, they can heal, not always, but when you get broken mentally, it's a really tough process to come back, isn't it?
Very hard healing and return process from that. So the employer, it's almost like the employer's responsibility to the workers are sparked even higher to make sure that they are protected so they don't deteriorate.
And look, the reality is the employees are the company's biggest asset. And employers have got to understand that, because at the end of the day, if the employees are working happily, it's amazing how their productivity increases. And if they're not happy, it sort of spreads like wildfire, doesn't it?
It's we see that commonly in workplaces, don't we, Tony?
Yeah, of course.
The vibe is good, the employers are good, and the employees are working well together, then there will be no issue, really.
Of course.
I think this case also highlights that if you are in a certain job or occupation where your workers might be susceptible to specific psychiatric injuries, you have a duty where it's reasonably foreseeable to mitigate the risk of them sustaining that injury. Whether that's police work, emergency services work, or even simple media type of work where they're, susceptible to, having to report on very graphic, violent types of incidences. So,
of course. Look, the thing I found is this: a bit of common sense has got to kick in. These employers have got to understand that if you subject someone to repetitive type work, they're going to get repetitive strain injuries. Subject someone to some pretty chilling, traumatic, horrific type of events, you can end up with some sort of psychiatric condition. So the employers have to be a bit smart in the way they do business, rotate people, share the duties, just sit down and talk to them, communicate with them and see how they're travelling, because a lot of the time they don't even know that, do they?
Absolutely. And sometimes, although it can be great that we see in this space that EAP services could be offered to employees, it's just not enough necessarily for the employers to say this is what we're offering and therefore we're protecting our workers to be able to utilise that service. There is much more stricter obligations on the employers to be able to protect the workers, especially when they know that the employees could potentially suffer or are suffering, especially after those complaints.
Under the Workcover Rehabilitation Act and whatever else it's called these days, and occupational health and safety rules and regulations, the non-delegable duty on the employer is very high, isn't it?
Yes, it is.
And Nadine, the employer's got to do a work, they've got to inspect each person's duties to ensure that they're safe.
Exactly. It's those reporting requirements that cannot be opted out by any employer. It's very strict obligations on them.
And the funny thing about it is every time we do a common law case and you on discovery ask for the inspection the employer's done of the person's work duties, they can never produce a document, can they?
Miraculously, they're never there.
Yeah, it just does not appear because the inspection's never occurred.
In many cases, yes.
Yeah. We can talk about a lot of things, but the important thing is I think the workers need to get advice, correct? You cannot assume you know what you're doing. You think you know what you're doing. And I've had cases where they've got advice from non-lawyers and they've come up with all sorts of nonsense, I can't tell you.
Also, look, if you are suffering from a psychological condition at work, you should tell your employer. It's not like the old days where they'll just tell you to suck it up. Most employers will be understanding and they'll have to report it. So make sure that you're very explicit in what you tell your employer if you're not coping at work.
And take it one step further, make sure that there is a paper trail of those complaints.
And also go and see a doctor.
Exactly.
Because, see, the whole thing around doctors and psychs and psychologists is that there's a corroboration of your story.
Of course.
Isn't that right?
Absolutely. The medical evidence also has to support what has happened to you at work. It has to tell the story.
Viewers, thanks for watching and listening. Go to our social media platforms. Please stay tuned for future episodes and always remember to stay safe.